Um, Hello, everybody. Thanks very much for joining us in our Stuart's Expert Witness Training webinar. I'm Nick Knowles. I'm a partner in the Clinical Negligence Department, and Nadia, my co-presenter, is a Senior Associate as well there. This is the first talk we've actually given on clinical negligence in all the time we've been providing these expert witness sessions. So this is the first one devoted solely to clinical negligence. It would be helpful if you could possibly save any questions you have till the end, and you can use the Q&A session to put them in throughout the presentation, if that helps. What we're going to cover today is what a clinical negligence case involves, and I'll be giving a case study, and we'll look at some lessons that can be learnt by clinicians. Nadia will be looking at the issue of consent, and we'll be dealing with the pitfalls of poor documentation and administration, and Nadia will be giving some examples of that, and then we'll round off by looking at how basically to avoid being sued. In Stuart's, this is what we do. Basically, we have a clinical negligence department separate from a personal injury. A lot of firms don't have that, they have them combined. But what we have different is a dedicated team of investigators whose job it is to get all the medical records, which can take quite a while, and write up the medical, the witness statements, and then send out instructions to experts. And what we try and do, the goal is to try and reach at the earliest possible moment a position where we know what the claim is and against whom and what's involved. And we find that this speeds the process up, because if we were all having a mixed bag of different stages of cases, then the cases in court being litigated would always take precedence over anything else. We like to say that we can find out in about a year or 18 months at most that we will have the case clarified and ready to go into court. And what we try and do is get liability established as soon as humanly possible, because once that's established, we can then ask for interim compensation to look after the client's immediate needs, whilst the long process of quantifying the damages is gone through. How a clinical negligence case works. Well, when you go to court, you're only ever going to get damages in money for your injury. If you want to complain, you have to use the complaints procedure. All healthcare professionals are capable of being the subject of a claim. And in the NHS care system, claims are brought against the NHS Trust, who is vicariously liable, which has responsibility for the acts and omissions of its employees. And the NHSR is the litigation body that will defend the trusts. In the private health sector, we have to proceed against the clinicians personally, and hopefully they will be insured with one of the protection societies, either the MDU or the MPS or the MDDUS. The burden of proof is on the patient claimants to show the case, and they have to establish breach of duty, that there was substandard care provided by the clinicians involved, and that caused the injuries complained of. There is a limitation period, which is basically 3 years from the date when the injury occurred, or from the date when the patient ought to have known that he or she should have a claim. That's much later, of course, in cases like cerebral palsy, which don't come to light after many years sometimes. Where protected parties are involved, that is children or people who lack mental capacity, then the limitation period is different. The 3-year period in the case of a child runs from the time when they reach the age of majority, that's of course 18, so they've got until the claimant has until 21 to issue a claim in court. And for a protected party, if they lack a mental capacity to litigate, then throughout the period of their incapacity, the time does not run. So for your average brain injured, severely brain injured person, there will be no limitation period. So to establish breach of duty, the claimant has to show that the standard of treatment fell below that of a reasonably competent clinician. And the courts apply what's called the Boland test. That's the name of the case that established this, where a clinician will only be negligent if there's no reasonable body of clinical opinion which would have acted in the same way. So the courts rely on medical experts, and they have to be independent, so they can't know any of the people involved or be close to any of the action concerned. There is an overriding case of Bolito, where if the defendant is relying on a particular responsible body of medical opinion, the judge can analyze that opinion and see whether it's reasonable and logical. But we've hardly ever come across cases that override the medical opinions of the experts involved. Clinicians are held to the same standard regardless of experience is a general proposition, and I'm sure there must be situations where that probably should not apply. But on the whole, that is a general rule. And a case, of course, can still fail even when there's been a breach of duty, because you need to establish causation. Causation is a very complex area of the law, and we've had several seminars devoted just to that issue alone. But the breach of duty must have caused the injury, or at least have materially contributed to the injury. And the patient must have suffered avoidable harm. The general rule, the first rule, is basically the but-for test. So, but for the negligence, but for the negligence, would the injury have still occurred? So, if proper treatment had been given to the patient, would they still have suffered injury? And if not, of course, then there is no claim. And oftentimes we do manage to establish breach, but we can't show that that was actually causative of any injury. So, Nadia, I think I hand over to you for the sort of governmental figures on those cases.
Thanks, Nick. Yeah, so how common is clinical negligence? In the latest NHS resolution report, 10,284 cases were brought last year. So actually a relatively small amount compared to the millions of people that are seen in the NHS each year. Of those figures, 5% of those cases were GP claims, which are now brought within the NHSR data and insured by NHSR. And if you compare that to the figures in 2019, 2020, which is the sort of next comparable year, trying to take out the data or the year skewed by COVID, cases have gone down. Also, when you take out that GP, around about 2,000 GP cases. Interestingly, according to the latest report, 77% of cases were settled without litigation, which, you know, we think is quite a large amount, and is probably due to more recent and better collaboration with defendants on cases. And in terms of the total cost, in that 2019-2020 year, it was 2.3 billion, which is obviously a lot of money. It was about 1.6% of the total NHS budget. But you may or may not be surprised to know that around about half of those costs relate to brain injuries during birth. And because of that, the government is investing a huge amount of money to pilot interventions aimed at reducing those injuries and the associated costs. Interestingly, only about 1% of cases, of clinical negligence cases, actually go to trial. Year on year, that statistic remains about the same. It's normally between 1 or 2% of cases. So actually incredibly rare. Back over to you, Nick, for an interesting case study.
Thanks, Nadia. This is a case where Nadia actually investigated it excellently, and I took it over into court once we'd established who to proceed against and on what basis. This was actually in the field of private healthcare, funded by the patient's healthcare insurer. He was a 58-year-old male with a history of hypertension and spinal degenerative disease. He previously had 3 successful spinal procedures, I think by the same surgeon ultimately involved. He saw his GP complaining of pins and needles in his feet, and he was referred privately to the same neurosurgeon he'd seen before. He undertook an MRI scan, which showed, he thought, no indication for surgery, and he decided to review the patient in 4 weeks' time. At that time, at the review, the patient had intervening ascending numbness in his left leg and felt heaviness in both legs. And the surgeon, on reviewing the MR imaging, noted the definitive cord compression in C3, C4 and below. I should say here actually that although in his letter he pointed also to the symptoms, the intervening symptoms, ultimately when we came to look at it, our expert evidence established that in fact there was no cord compression that was discernible on the MR imaging. And part of our neurosurgical evidence was that the operation should never have been undertaken. However, the surgeon went on to discuss the 2 options for surgery, which he felt was laminoplasty and laminectomy. Laminoplasty is where the posterior bony arch of the spine is hinged upwards and secured with metal plates to increase the diameter of the spinal canal. And the laminectomy is an older-fashioned procedure which involves removal of all the lamina and spinous process. But what he didn't do was go on to explain what the risks were involved in this surgery, nor what alternative treatments were available. So the operation took place 6 weeks later at the hospital, which was actually owned and run by the patient's healthcare insurer. He signed a consent form just before he went into theatre, and our evidence was that that was far too late and too close to the operation, giving insufficient time and space to the patient to consider the risks of surgery. And during the surgery, sadly, he suffered a severe hemorrhage and ended up losing about 2.7 litres of blood, which is more than half his circulating volume. But the surgeon and the anaesthetist pressed ahead, and he performed a multi-level laminoplasty on several sections of the cervical spine and closed the site. In recovery, the patient was found to have no motor function in all 4 limbs. And an urgent MRI showed compression of the spinal cord in the area of the laminoplasty. And he was urgently returned to theatre. By this time, for some extraordinary reason, the anaesthetist had left to attend to his non-urgent NHS practice at his local hospital. And the surgeon had to engage another anaesthetist, but they successfully removed the hematoma, but took out all the metalwork and performed a laminectomy. And the patient was discharged home after a long stay in hospital and rehabilitation about 8 months later, and he was classified as a spastic tetraparesis C3 Asia D, but functionally Frankel grade C. He couldn't walk, he had limited upper limb function, needed a hoist for transfers, 2 carers all day and night. He was doubly incontinent and suffered spasms and pain. And the outcome of this, we used 4 medico-legal experts on breach of duty and causation. And we proceeded against the surgeon and the anaesthetist. We managed to obtain a default judgment against the surgeon, who didn't defend at all. But we had found out that he did not have any professional indemnity insurance cover at all. So the case against the anaesthetist was particularly important, and he disputed all liability. So the breaches against the anaesthetist were effectively jointly, the same, amongst the allegations we used against the surgeon, that they failed to ensure group and save was undertaken before surgery. And here they failed. The hospital surgical safety list showed that the surgeon had given a risk of bleeding in the surgery of more than 500 millimeters. And this therefore mandated, in accordance with the protocol, group and save before the operation. So again, the operation should never have taken place before this happened. But it having started, the anaesthetist failed, of course, to ensure that the surgery should have stopped until hemostasis was achieved. And he failed to give blood products because there weren't any, both before but also after the procedure. He gave colloid and crystalloid products, which only maintains volume transiently because it's quickly absorbed into tissue. But of course, those products don't have the oxygen carrying of the blood products or the clotting abilities of blood. So that didn't help very much at all. And the failing to keep proper records was not only in relation to doing the proper paperwork under the protocol, but his own clinical records were pretty sparse and bleak. And then both he and the surgeon failed to report this as an untoward incident. And it wasn't until about 2 years later that the hospital, under promptings from the client, finally did a serious untoward incident report, and that was highly critical, but mostly critical of the anaesthetist. And after several years of litigation, because the anaesthetist would not reply to any of our pre-action correspondence at all, and for various other reasons, unfortunately the patient died just before trial was fixed to take place. And we managed to achieve a 7-figure settlement just before the trial was fixed. So the lessons we learned from this case, well, follow guidelines or protocols, nice guidelines or local health hospital protocols might apply to your treatment. And good record keeping avoids litigation. And it said that no records equal no defense. If you can't show that there's a note that something's been done, then the court might well imply that wasn't done, despite what you might now say, or the defendant might now say. So I'll hand over to Nadia for the rest of the talk.
Thanks, Nick. I wanted to start by talking about consent. It's a fundamental principle of healthcare, but it's also an issue that we see crop up very regularly in our cases, and in Nick's example there as well. As you know, the principles are well known. Consent has to be voluntarily given, which means a pushy family member wouldn't be able to provide consent on behalf of a family member. Of course, there needs to be capacity in order to provide consent. But most importantly, and this is where we see issues arising, there has to be the correct information given for the patient to make an informed decision when providing consent or not. There's quite a famous case, which a lot of you may know about, called Montgomery and Lanarkshire Health Board. It's an important case because it really highlighted this crucial importance of informed consent. In terms of the background, Mrs. Montgomery was pregnant. She was small in stature and she also had diabetes. She had been told that there was a risk of her having a large baby. She was understandably concerned, but at the appointment with the consultant obstetrician, although she said she was concerned, she didn't ask specific questions about risk. And the consultant decided not to tell her about the risks of shoulder dystocia and also cerebral palsy. And he also decided not to tell her about the alternatives, which would be to have a cesarean section rather than a natural vaginal birth. Now, unfortunately, what happened was the baby did get stuck due to him being very large, and he suffered shoulder dystocia and unfortunately also cerebral palsy. This case went all the way to the Supreme Court, and the reason why is because it was really looking at the concept of kind of medical paternalism as opposed to patient autonomy. And in the case, the consultant obstetrician explained the reasons why he didn't provide that information is because he thought it would sway Mrs. Montgomery in her decision, and he thought she probably would opt for a cesarean section had she been given that information, and he didn't think it was in her best interests. But what the Supreme Court held is that it's for the patient to make the decision based on all of the information available, and no information should be withheld. And it's really the role of the doctor to know the position that the patient is in and provide all of the information that you think that they might need to make an informed decision. And in the judgment from the Supreme Court, it was held that the doctor is under a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments. And the test is whether, in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. So it really puts the patient at the centre of the decision-making process. So an example of sort of administration errors and the importance of good record keeping. This is a case that actually Nick Todd and I did, and I know he might be on this Zoom training today. This case actually went to the High Court, and there were many complex issues surrounding causation, but what I want to tell you about is the breach of duty issues in this case, because it really highlights the errors that can happen and the consequences that can occur. So this patient had radiculopathy, causing pain in his right arm and restricted movement. He had an MRI scan and saw his consultant neurosurgeon, and a discussion was had in the clinic about surgery, if he were to have surgery, and what would happen, the risks and what it would involve, and also conservative management by way of physiotherapy. And what the consultant advised was that the patient should go away, have physiotherapy for 3 months and come back, and they would see how he's getting on and make a decision at that point about whether surgery would be required. Now, what actually happened is after this clinic appointment, the patient was actually accidentally put on the list for surgery. And not only did that error occur, but the clinic letter, which outlined the management plan for physiotherapy, wasn't typed up in a timely manner, which meant that the next correspondence that the patient received was actually a preoperative assessment appointment inviting him to come in. Now, he was understandably a bit confused. He did call his GP initially, who hadn't received anything from the hospital at all, so couldn't really help. So instead, he decided to call the number that was at the bottom of the letter and spoke to one of the secretaries. And the judge was very sympathetic, actually, with the claimant during the trial, because what the claimant said was when he called up, his call was answered by quite an abrupt secretary, and he asked her, well, I received this letter, I think it might be an error. Do I need to attend this appointment? And she said to him, well, if you don't attend this appointment, you'll be put to the bottom of the list, won't you? So understandably not wanting to be put at the bottom of any list, he turned up. And I think what swayed the judge in this case in terms of breach of duty was the fact that there was then a series of missed opportunities to really set this management plan back to where it should have been, because he attends his preoperative assessment and the neurosurgical SPR who assesses him and talks about the risks of surgery doesn't go back through the notes and see that actually he shouldn't be at this preoperative assessment, he should be having physio. And that carries on because when he then turns up to hospital for his actual surgery, again, no one looks back at the notes to realise that he shouldn't be there at all. And unfortunately, what happened during the surgery was a non-negligent damage to his nerve, which ended up causing him significant problems with his right arm. And again, it was said that on the day of surgery, you know, even then there were opportunities missed to set the management plan back to how it should have been. And it's really the lessons learned from that case is those clinic letters should be sent out quickly in a timely manner. So that everyone knows, you know, what is supposed to be happening, so these mistakes can be easily avoided. And the importance really of always checking through records of previous appointments to make sure you're, you know, well versed in terms of all the advice that the patient has previously been given. So another example here, this is again a real case that I did a few years ago. And another example of quite a small error having a big consequence. So this particular patient was having problems with her eyesight. She went to Specsavers and they were worried about her visual fields. So they wrote a referral to the patient's GP. The GP forwarded that referral on to the local eye hospital, and importantly, she had recently changed address. The GP had the new address and put her new address on the letter, on the referral. However, the local eye hospital didn't update their records and still had the old address. They sent her an appointment. At that time, she had her postal redirection service in place and she attended the letter for the appointment. At the appointment, they were sufficiently concerned and wanted to arrange an MRI for her. Unfortunately, again, her new address isn't noted and the MRI appointment letter is sent again to her old address. But by this time, her postal redirection service is no longer in place and she never receives the letter. And essentially, she misses her appointment for an MRI. They also did not send a did not attend letter to the GP when she didn't attend her MRI appointment. And again, more missed opportunities, much like the previous case. In the end, she went back to Specsavers when her eyesight continued to deteriorate, and the re-referral process was back in place. And by the time she did have her MRI, it was revealed that she actually had a tumour compressing her optic nerve, and you know, the defendant admitted breach of duty for failures to update her address, which led to quite a significant delay in the diagnosis of this tumour. I did say at the beginning this was a few years ago, this case, and I do wonder if this happened today, the fact that most NHS services send out a text message now reminding you of your appointment probably would save this same sort of thing happening again. So just to lighten the mood, these are some real examples on the slides of things that we've seen in medical records. On the second day, the knee was better, and on the third day, it disappeared. The patient has been depressed since seeing me in 1993. And I've seen this one personally in my own records. The patient is numb from her toes down. So try and avoid those misunderstandings if you can. And I wanted to touch on the reasons why people sue, because actually, and importantly, quite often when people come and speak to us, they don't realise they have a clinical negligence claim some of the time. They come to us because there's been one aspect of their treatment that they're really unhappy about, and they want to make a complaint, or they want more information. And I'll give you some examples. One patient that came to us quite a few years ago, she was a very anti-litigious person. She was a teacher. Her husband was a lawyer, but he was a corporate lawyer. He wasn't in litigation. They did a lot of charity work, you know, and they weren't the sort of people that would like to take on litigation. But she had bowel surgery, and as part of the pain relief, she was given a spinal anaesthetic, and post-operatively she couldn't move her legs, and understandably she wanted to know what had gone on. And you know, being fairly astute and intelligent, and with the help of her husband as well, they wrote a really good letter of complaint to the hospital, and the hospital did carry out an investigation and produced a root cause analysis report. But the report, to our eyes, was a bit of a whitewash, really, because it didn't really explain anything that had happened, and pretty much said it was just one of those things and there weren't any lessons to be learned, and it couldn't have been avoided, which understandably she was very frustrated by. After coming to us, we obtained her medical records and, crucially, the anaesthetic record chart, which actually showed that we don't know the exact number because it had been scrubbed out on the chart, which is always suspicious. But it looked like the number that had been scrubbed out was a number 9. So it looked like there'd been perhaps 9 attempts to cite this spinal anaesthetic. Upon drafting the letter of claim to the defendant, they very quickly accepted liability. But that could have been avoided, I think, if they'd been more open and honest in the root cause analysis report. Another example of a patient that came to us, and this is a case that's actually really recently settled just earlier this year. And well, his family came to us actually because they were really, really upset about a single piece of treatment that their dad had received. So he had been in hospital after falling downstairs, and progressively his symptoms had got worse to the point that he could no longer move his arms and his hands. When he was laying in the hospital bed, one of the doctors that came to see him didn't believe that he couldn't move his arms and hands. And this patient was an alcoholic, whether that played a part in you know, the reason why the doctor didn't seem to believe him. But the family reported that what she did was she actually raised his hand above his head and let it drop, smacking him in the face, which obviously they were appalled about. And that was the reason they came to us, because they were so unhappy about that treatment. And it was only after going through the story with them that, you know, there was actually an earlier hospital attendance, and there were quite clearly instances of negligence, completely unrelated, you know, to what they were unhappy about. So again, you know, if that hadn't have happened, I don't know if they would have come to us. And another example of an ongoing case actually is a patient who is autistic and has trouble communicating sometimes. And the neurosurgeon who saw him with suspected cauda equina syndrome told him he needed an MRI. And this patient tried to communicate that he was happy to have an MRI, but he was in so much pain, could he please have some pain relief? And an argument ensued between the patient and this doctor. And again, he was so unhappy, he wanted to make a complaint. And again, once we actually had a look through what happened and got the medical records, there'd been a prior attendance a few days earlier where actually his cauda equina should have been picked up. And again, it's a case that came to us not actually because of the clinical negligence. And I suppose the lessons to be learnt from that is it can just be small instances that can taint what is, otherwise overall very good care. So in terms of conclusions, we can't really say strongly enough the importance, and I'm sure you all know this anyway, of records and good record keeping, and making sure those records are reviewed prior to any appointments. Taking that time to properly document discussions with patients and their family, particularly in relation to informed consent, making sure they've got all the information, not just about the, any procedure or treatment, but about any alternative treatments as well. Crucially, follow those policies and procedures your hospital has in place, because as Nick's case demonstrated, often those policies and they're in place, and if they're followed, it can avoid some of the issues happening in the first place. And all of those small points in relation to administration, making sure documents are kept up to date in relation to patients' addresses and that sort of thing, can be really important. And I suppose we'd just like to conclude in a way with saying, be the good experience your patient remembers, because it can be that one small thing that can taint overall care, which is in the most part usually very excellent. And the last thing we wanted to mention is, despite us saying we're a litigation only firm, and that is true, we do only do litigation, but we have a pro bono department as well, actually, which is really important to us and really important to some of the clients and the patients that we see, because understandably they're often in a very difficult position, and not being able to work, being in hospital means sometimes debts either can't be repaid or debts start to mount when people can't work. And we help actually a number of patients with all sorts of pro bono sort of non-compensation issues. A recent example for one patient is we had £19,000 worth of debt written off. And another area we regularly help with is things like critical illness policies. If an insurer has taken quite a strict interpretation of policy wording and say they don't want to pay out because it doesn't, meet the criteria, we often, on a patient's behalf, and even when they're not clients of ours, we'll fight that with the insurer for them to try and get the payout that they're entitled to. So that actually concludes our talk. We hope you found it interesting, and we'd be really grateful if you've got any questions or comments for us.
There are two questions in the that I can see. The first one, Nadia, possibly you could deal with, is consent. How much information is sufficient for the patient to have?
Yeah, thank you for that question. I mean, the answer is it entirely depends, unfortunately. It depends on your patient. It depends on whatever treatment it is that you're recommending or not. And it is judged on a case-by-case, patient-by-patient basis. And, it's just a case of, what the risks are, what the alternative treatment is, and it's your duty to provide that information, and that information will be different each time with every patient. So I'm afraid I can't give you a more definitive answer than that.
It is a difficult one, and it is very case specific, I'm afraid. It's just, how much is reasonable, really. How much would you expect to have in order to weigh up whether or not to go ahead with a particular type of treatment. So there is a couple more questions. One is, in birth injury cases, there's often a very long delay in reaching a conclusion, many years, which causes enormous stress for the family, occasionally with breakup of the parents. The delay is often for determination of life expectancy, which is uncertain at whatever age it's done. Is there any way of reducing the delay in these tragic cases? It's right that in birth injury, they take a long time. It may be because they haven't been uncovered for a long while in the first place, but even when they are identified, it does take a long time, because we need, in order to show breach of duty, we need an obstetric opinion. And there aren't terribly many obstetricians who are doing this medico-legal work. But worst is the pediatric neurologists who we need in order to link the breach of duty to the injury by way of causation. And there are very few pediatric neurologists. And of those, there are very few that actually do medico-legal work. And of those, there are very few that are actually free to do any new cases, because a lot of them have already closed off their case list, or they may give you an appointment 1 or 2 or 3 years hence, actually. But the other problem, the delay is not so much, well, determination of life expectancy. Often the condition and prognosis expert will say, well, I can't, this child is too young for me to know exactly what lays in store for it in the future in terms of surgical intervention if it's an orthopedic problem. So some people say, well, we can't really give a proper opinion until they've reached the age of skeletal maturity, sometime in the teens. So that delays things as well. Life expectancy, a lot of the heat of life expectancy is taken out by having care paid each year instead of for as long as the person lives. So that cures that problem. But basically litigation is supposed to be final. So the court can't rule until everything's in, all the evidence is in, which is a problem. Apart from the odd exception like provisional damages. Provisional damages, if you can identify something that might happen within a particular period of time, then you can finalize your case, and then you can, on the basis that you can reopen it if that eventuality comes to pass, because maybe there's only 3% of it ever happening, but if it does happen, it's going to affect the patient massively. And that does affect, so that's a sort of exception to trying to finalize everything. And the other aspect of what that question implies is unfortunately, whatever happens to the family is not in law compensatable. And it's absolutely right that, you know, it is a stress, massive stress for the family. Parents do break up under the strain of it all, but the law doesn't compensate them at all, because the law will only compensate the victim of the negligent care. Sometimes you can work in some psychological backup. You can try and introduce under some other guise, but on the whole, you know, unfortunately, those sorts of horrific outcomes for families just can't be compensated for at all. But the other thing that I would say, again, is that if we can get interim damages, which means us resolving liability as soon as possible, at least we can get that done. There isn't any delay about that, because we can show what the breach of duty was, and we can show that it caused the injury on the whole. And once that's decided, subject to getting hold of an obstetrician and a pediatric neurologist in reasonable time, we can then immediately ask for interim damages. And I've got a case where, you know, we've on an interim damages basis, we've got full care for the client, and we bought all suitable alternative accommodation, which we're now trying to adapt. But everything that our client needs in that case, although a trial is several years off, sadly, but at least all her needs in the meantime are met until we've gone through the massively long process of quantifying damages with a whole host of 8 or 9 other quantum experts involved as well.
I think I can probably do the next question next. It's about consent from Mr. Desai.
Yes.
So this is the question: following discussions of all treatment options, if a patient opts for an option not in their best interests, how do you deal with that situation? And I think the first point to note with that is it is the patient's decision at the end of the day in terms of the treatment that they opt for. They can only be provided, obviously, with reasonable treatment options. So, for example, if surgery is not a treatment that is being suggested to them and they would like to go for surgery anyway, you know, it's not a case of a patient making decisions about treatment options that wouldn't be available to them. It's only the decision being made on the ones that are reasonable. And I suppose if you think it's not in their best interests, where I suppose this is probably seen most often is in oncology cases. You know, some patients may opt perhaps not to go for chemotherapy, surgery, whatever it is that is being recommended in their best interests, and it is their decision. And I think if a patient is ever opting for treatment or, you know, refusal of treatment that is not in their best interests, you know, all you can do is give them the information and note that very clearly in the records. But, you know, that's it. It is their choice. The next question.
I can't see another question, Nadia.
Oh, this is Edward McIntosh. We've seen a roughly 3-fold increase in complaints since COVID lockdowns ended. Have you experienced any changes in your practice? And are these likely to affect what we do? I don't know if you want to cover this, Nick.
Yes, I mean, there are some lawyers I know who are sort of storing up, you know, COVID cases that arise because of COVID and the complications involved. We basically look at each case as we look at any other case. You know, COVID is a catastrophe that's, you know, severely afflicted everyone and had a massive effect naturally on the practice of clinicians. So we don't really look at them any differently. In fact, our after the event insurers will not look very closely at any cases that do involve COVID, because if they do, they won't cover us, so we simply can't do them. Having said that, we have got 2 cases that sort of secondary damage occurring during COVID as a result of COVID. I think more people were nursed on ICUs in prone position. And we have a couple of cases where, unfortunately, the patients have suffered brachial plexus injuries because they weren't properly manipulated and moved. I mean, the practice of that is well seen in prolonged operations where the patients have to be placed because they're going to stay in that position for a long time. You have to look after them. So I don't see any difference in that situation from a patient who might have suffered during the course of an operation. But I hope it doesn't make any difference to most clinicians' practices. And I hope there won't be a plethora of claims unnaturally arising out of the COVID experience and people taking advantage of it. But there is an area which is going to, I think, be looked at rather intensely is the delays in treatment of cancer. I think there's a lot of claims that may arise as a result of that, which is, but each case has to be viewed on its own particular facts. And I don't think it'll change anything from our perspective anyway.
The next question, Nick, is how do you deal with compromised mental capacity and consent, many of them on being sectioned under the Mental Health Act? I mean, quite simply, if a patient doesn't have mental capacity to make a decision about their healthcare, a decision has to be made for them, obviously in their best interests. You know, as long as you're clear that they lack the mental capacity, and obviously you have to make an assessment and document that accurately, then you're able to make a decision for them on their behalf.
They may have a deputy giving healthcare deputy who would be looked to for instructions and for what to do in that situation. But on the whole, the law says, well, you've just got to do your best as long as you're acting in the patient's reasonable interests, and you're liaising with all the family, anyone who should take part in the decision-making process. You've just got to do your best, really, but with the right people.
And the last question is about malingering. Malingering, how do you ascertain? Apology for overwhelming you with, I'm not sure what QS is.
Questions.
No questions.
No problem.
Oh gosh, no worries at all. We like questions.
It's a good question.
It is, yeah. Do you want to take this one, Nick, and maybe I can chip in?
Well, I mean, it is difficult. Rather like pain, you know, how much pain is someone suffering? Are they actually being real? Are they being truthful in what they tell you? I suppose, I mean, I don't know, looking at it from a sort of layman's perspective, most people don't really want to be ill. They like to be healthy. And most people do know more about their own body and its intricacies than anyone else does. It's very subjective. But again, you've just got to do your best with the available information. I mean, obviously, you could look at their medical records and see, you know, what information is helpful there. But it is a problem, because some people, you know, do overrate things and exaggerate, and it can't be easy to deal with. So I'm sorry you have to put up with it, but I can't give you any real guidance as to how to overcome that.
What's quite helpful actually is whenever we see a new client and, you know, we're considering taking on their case, and we have to discuss with them things like funding. You know, the courts are very clear that if there's a finding of fundamental dishonesty, a claim can be struck out, and that can therefore also reverse a rule that we have in relation to costs that's called qualified one-way cost shifting, which means if you bring a case against the defendant and you lose, the defendant can't ordinarily claim their costs from you. However, if the case has been struck out due to fundamental dishonesty, then, you know, that dishonest claimant can actually find themselves with a very large bill for the defendant's and the claimant's costs. And it's something we always make very clear, you know, to every client at the beginning, you know, the importance of honesty, what can happen, you know, in a finding of fundamental dishonesty. But luckily, I mean, I think we'd have to say the types of cases that we deal with at Stewart's, it's incredibly rare. And I think, as Nick alluded to, where we would see it most often is actually sometimes in cases where clients have a psychological disorder, like a conversion syndrome, a conversion disorder, and then it becomes very, very difficult for us to try to work out to what extent their injury is as a result of a conversion disorder brought about by the injury, and a conversion disorder that's been brought about by the negligence. It becomes very complicated, and but as Nick was saying, for most of our clients, they wouldn't wish to be in the position that they are in. Many of them are very, very severely injured, and you can see from their records that most of them are honest, but there is always the small minority, but we're lucky at Stewart's that it tends to be a minority for us.
Well, thanks very much indeed for all those questions, and thanks very much indeed for joining us today. I just mentioned our next webinar is on the subject of contributory negligence on the 1st of November. And Nick Todd, a neurosurgeon, will be looking at it from in the context of road traffic accident claims and the medical perspective, and the legal implications will be reviewed by Isaac Hogarth of 12 King's Bench Walk. As I said, that's on the 1st of November. It'd be great if you could join us, but otherwise, thanks very much indeed for coming in. I hope this has been of some help to you.
Thanks very much.